Okay, Emily, I'm good on my end whenever you're ready.
Okay, sounds good. Everyone ready? Let's get started. Good morning.
Morning.
My name is Emily Supinger, and I'm the chair of the Zoning Board of Appeals. I would like to take a minute to remind everyone about the rules of this proceeding. This proceeding is at all times governed by the rules of procedure adopted by the board on October 17th, 2011, as amended on February 20th, 2014, May 18th, 2017, and January 17th, 2019. A copy of the rules of procedure is available for review online. This is a quasi-judicial hearing. As such, the board reserves the right to deliberate in private. The Ohio Rules of Evidence do not apply to this hearing. However, professional rules of conduct do apply, and candor to the tribunal is required. The board members are citizen volunteers and are not paid for their service. They are treated as public officials under Ohio law. Any attempt to influence them, including but not limited to bribery, intimidation, retaliation, which may include contacting their employer in an attempt to exert influence, is punishable as a crime. All should be aware that this meeting is being recorded. Therefore, please speak clearly into the microphone and state your name and address for the record. In the event of any technical difficulties with the video conferencing technology, I may continue or postpone this hearing at my discretion. All participants providing testimony must have both camera and audio features turned on in order to participate. With that, let's proceed to the first case. We have one matter on the agenda today. ZBA case Z4058-2021 regarding 1617 Elm Street and 1621 Logan Street. We are here solely on a motion to dismiss that has been filed by the appellees. I think what we'll do is we'll let Mr. Tepe and Mr. Burke present argument. We'll allow Mr. Suter to respond, and if Mr. Tepe and Mr. Burke would like a short rebuttal, that will be allowed too. If the board members have questions, I think during argument, since this is a legal issue, I think it would be appropriate to ask questions during argument if anything comes up that you need clarification on. Okay, so we'll get started. Mr. Burke, Mr. Tepe?
Thank you and good morning. You guys can hear us okay? Still trying to get used to these Zoom meetings. I, along with Tim Burke, represent the owners/developers of this project. Stephen Dronin here is a member of the development ownership team. We have other members of our team who did not Zoom in, rather they are viewing via the link that Cassandra was so nice to send to us. I'd also like to introduce Cassidy Michael, who is going to be a third-year law student. She's a summer associate with us this summer, and she's trying to figure out what the zoning world is all about. So thank you for your time this morning. I would like to bring up a point of procedure. We did file a reply brief in support of our motion to dismiss. There's a little bit of a quirk in the BZA rules. Mr. Suter did file his response on the last day under the rules. We did our best to try to put together a reply. We filed that with you, and we asked the chair and the board, please consider that as part of the record and take it for what it's worth.
Mr. Tepe, I appreciate that. I think given that the board members not had an opportunity to review that material, I think what we'll do is if you would like to address any of the issues you raised in that reply brief as part of your argument, I think that would be helpful. But for purposes of the record, since it's not before the board members and they haven't reviewed it, I think we will not include that in the record since it was filed out of time. I do understand the timing issue.
Thank you very much. The issue before you is pretty straightforward, right? It has been briefed. It's been laid out. This isn't one where you have to scratch your head too hard to decide whether or not the written findings of the Historic Conservation Board are appealable or not. The project has a history here. In 2016, Plan District 76 was enacted by City Council. A final development plan was approved by the Planning Commission in December of 16. Let's fast forward here to 2020. My client sought and received a major amendment to PD 76 to add property to it and to modify the plan. City Council legislatively approved that major amendment. And as you know, the final step in the PD process is the approval of a final development plan. Keep in mind, This property is a planned district and is located in the OTR historic district, which gives it special provisions in the code. If this property were not located in a PD, rather it was straight zoning CC-A or some other straight zoning classification, certificates of appropriateness would need to be sought by the Historic Conservation Board, and those, the code is very clear, are appealable. They are the final say in property being developed in a historic district. However, in this situation, because the property is zone PD, there are special provisions that apply. And these are laid out in the code. They're not hard to find, and they have their own titles. Because it's a PD, there's two steps. There's two steps for a final development plan approval. And that's governed by 1435-011, titled Relationship to Planned Development Districts. And the code says that the Planning Commission shall receive written findings from the Historic Conservation Board. If you look at 1429, it's 1429-05D. This is in the Planned Development District Regulations. Historic landmarks and districts, and I shall quote, whenever a planned development application is filed for a property wholly or partially located within a historic landmark, historic district, or involving a historic structure, this is the operative part, the Historic Conservation Board shall advise is the word that is used, the Planning Commission relating to approval of the final development plan. So therefore, the first step in the two-step process is a stop in front of the Historic Conservation Board, who shall advise the Planning Commission as it relates to the certificate of appropriateness that may or may not be required. This was done, and on April the 7th, the Historic Conservation Board issued its written findings, its advice to the Planning Commission. That is what was appealed, and that is what brings us here today. But recall, the code is very, very clear on a final development plan approval in a PD. You must go to the Planning Commission to get approval of the final development plan in a quasi-judicial proceeding. It must be in substantial conformance with the approved concept plan and development program statement. That was done, and that written appealable decision was issued April 22. That's Exhibit 1 to our motion. That was not appealed, and that deadline has long passed. So how does the HCB, Historic Conservation Board, advise the Planning Commission? Well, the operative section here is 1435-0112, Relationship to Planned Development Districts. And this talks about whenever a planned development district is located within a historic district, yada, yada, it goes on. It says, the more specifically, the last sentence of the first paragraph, the process for reviewing and issuing a certificate of appropriateness, the process for reviewing and issuing a certificate of appropriateness in a planned development district is as follows. B is the operative one. Final development plan approval stage. The Historic Conservation Board shall review all final development plans submitted for the creation of a new planned development district located at the City Planning Commission. It goes on to say, in reviewing a final development plan, the City Planning Commission, strike that. It says that the Historic Conservation Board shall make written findings to the City Planning Commission about its approval, conditional approval, or denial of any certificate of appropriateness identified. It shall written findings. Moving on, in reviewing a final development plan, the City Planning Commission, which is the final stop in this process, may overrule the Historic Conservation Board's written findings by 2/3 majority of vote of the Planning Commission, which shall constitute a final order of the City Planning Commission appealable to this board of the Zoning Board of Appeals. process is very clear. There's an interim advisory step to the Historic Conservation Board. There is then a final step in front of the Planning Commission for a final development plan approval, which clearly is appealable. Let's not throw common sense out the window. If the Historic Conservation Board's written findings are appealable, then how would you continue the process set forth in the code and get before the Planning Commission? Let's assume that the Historic Conservation Board says, we recommend against these certificates of appropriateness, right? Then how, and if that was appealable and someone did appeal it, then how would the Planning Commission exercise its right to overturn that decision by a 2/3 majority? Because if the Historic's advice was appealable, it would never get to the final step. And the code says that is the final step. I've droned on, I think, a little longer than I wanted to. The briefs are very, very clear. We've laid it out in both our motion to dismiss. I've hit the highlights of our reply. Madam Chair, I do respect the decision. We are available for questions, but the code couldn't be any more clear. If it's in a non-PD, just a straight letter zoning, the Historic Conservation Board's decision is final and appealable. If it is in a PD, it's only the Planning Commission's decision that is appealable. Thank you for your time. We're available for questions.
Thank you, Mr. Tepe.
Mr. Tepe, I have a quick question. How do you address the notwithstanding language that's contained in 1435.5.5 regarding appeals of certificates of appropriateness to the ZBA?
Well, I think you have to read that in conjunction with 1435, the section that 1435.011-2. If you were to accept that on its face, then that renders that entire section a nullity. I think that applies specifically to a certificate of appropriateness in a non-PD district. This is the only process for final development plan approval. I think what Mr. Suter relies upon is the section as it applies to non-PD property.
The notwithstanding language, as I read it, doesn't necessarily limit what it's not. It's notwithstanding the entire chapter 1435.
But then if you read that and then you read 1435.011-2B, how would the Planning Commission ever exercise its decision on the final plan? You can't read, it doesn't work. The Planning Commission's decision is the only final appealable decision, and don't forget the Historic Conservation Board shall advise the Planning Commission, advise the Planning Commission. That's 1429.05D as in dog. I appreciate the question, Mr. Benny.
Any other questions from any board members at this time? Mr. Suter, you can proceed.
Thank you, Madam Chair. Thank you, members of the ZBA and everyone who's joining us today. With me, I'm Sean Suter. I am with Suter LLC, and we're located at 455 Delta Avenue, Suite 203, Cincinnati, Ohio, 45226. I'm here this morning on behalf of a number of people, some of which are on the line and have joined in, two of which from Costa Rica. So they've got the best deal in the house here. It's always been my dream to actually do a zoning hearing from Costa Rica. So congratulations to the Levitts for realizing that. It's great to see everybody. My clients are the Over the Rhine Community Housing, Over the Rhine Foundation, OTR Adopt, Mr. Danny Klingler, Ms. Margie Waller, Ms. Jennifer LeMasters-Wirtz, Mr. Ted Levitt, Ms. Vicki Levitt, the Peasley Neighborhood Center, and Ms. Bonnie Newmeyer. So all very invested members of the Over the Rhine community for a long time. And it's a real honor to be able to represent them in this matter. So appellees are arguing essentially that the Historic Conservation Board's decision on the certificates of appropriateness and the City Planning Commission's decision on the final development plan are indistinguishable, and must not and cannot be appealed separately. That the right of the City Planning Commission to overrule the HCB's decision somehow makes the Historic Conservation Board's decision unappealable advice. That couldn't be further from what the law does in the plain reading of the law in the zoning code. And to go back to the conversation Mr. Benny and Mr. Tepe just had, look, if the code doesn't work, my clients should not be penalized for that. That's something that needs to be fixed in the code. But my clients have due process rights, and we shouldn't allow maybe inartful language in the code at best, or at worst, I should say, to deprive them of that. Now, I don't think it's inartful. I think it's actually very deliberate the way the code reads in 1435-055. And to Mr. Benny's point, notwithstanding, and I write a lot of contracts and things that use the words, the term notwithstanding, that means notwithstanding anything to the contrary in the code, the Zoning Board of Appeals has jurisdiction over certificates of appropriateness, period. That's the deal. That doesn't mean that the City Planning Commission cannot overrule a decision of the Historic Conservation Board in a PD. They can. But that does not deprive the Zoning Board of Appeals of concurrent jurisdiction with the City Planning Commission relative to this matter. The Zoning Board of Appeals powers are preserved by 1435-055. And we'll get into that in a minute. But I think what's really instructive here to rebut this notion that the Historic Conservation Board decision is not an actual decision, it's just a piece of advice that gets transmitted off to the City Planning Commission. The important thing to do is to look at the Historic Conservation Board decision, as well as to look at the City Planning Commission decision. So I hope you have those documents handy, and maybe you can follow along as I walk you through why it is apparent, not only in the title to the document, that's only one piece of it, but in the substance of the document. The substance of the document is very clear that it is intended to be a decision. First question I would have for the Zoning Board of Appeals and for Appalese is, why on earth would the city issue a written decision on April 7th by the Historic Conservation Board, and then issue another one 9 days later separately on the City Planning Commission? Why on earth would the City of Cincinnati issue what's titled a decision at the very top of the document, date of decision April 7th, 2021, if it intended to be a piece of advice and advisory to the City Planning Commission? If you look at page 1 on the Historic Conservation Board's decision, it jumps out at you in one of the headings, summary of decision. The certificates of appropriateness are approved. Approving something is making a decision. Denying something is making a decision. Approving something is not the certificates of appropriateness we advise that they be approved by the City Planning Commission. That's not what it says. It says they're approved. Look down to the next paragraph. It talks about the Historic Conservation Board being a quasi-judicial body empowered to approve a certificate of appropriateness. That is the case. The Historic Conservation Board has jurisdiction over certificates of appropriateness. The City Planning Commission doesn't. It has jurisdiction over the final development plan approval. And in the case where the plan development and the historic district overlap, that gives them a right to overrule the decision. It doesn't give them a right to make a decision on certificates of appropriateness. Okay, that argument was never made. There was no case made to the City Planning Commission that the certificates of appropriateness should be approved. That decision had already been made, and indeed was incorporated by reference in the City Planning Commission decision, which we will look at in a minute. The next paragraph talks about the Historic Board conducting a public hearing, talks about how there was a quorum. And to me, if it's simply advisory, why do they have to make a case that they're a quasi-judicial body conducting a public hearing where there's a quorum to make a decision? That's why. The board had a transcript of the hearing, a transcript of the proceedings. That's why do you do that? Because it's potential appeal, right? You don't make a transcript on some advisory decision. You might put out meeting minutes, but you wouldn't make a transcript. Look at the findings of fact on page 2. It talks about the evidence submitted and sworn testimony and the following findings of fact and conclusions of law. You make an administrative body makes finding of facts and conclusions of law when it's making a decision, just like the City Planning Commission did. It doesn't do that when it's giving advice, mere advice. You can see in section 5 on page 2 that there was testimony. Okay, I don't need to give sworn testimony on the record with a transcript being made to a body that's simply advisory to another body. But that aside, let's say that's just the procedure and they're following it, fine. Look down on page 3. It talks about the urban conservator making a report and a recommendation to the Historic Conservation Board. That's in the ordinary course of a certificate of appropriateness hearing. And the reports recommend approval. Reports don't recommend advice or recommend some suggestion, it's approval. And then you have to go to page 4, conclusions of law. The very first conclusion of law talks about evaluating a certificate of appropriateness under their authority under the administrative code. Number 3 talks about approving certificates of appropriateness upon a determination of evidence. This doesn't sound like advice to me. This sounds like a decision. Number 4 talks about this, and I think this is really key. We can read number 4. It says, CZZ section 1435-011-2 requires the board to review, quote, all final development plans located within or overlapping historic district, okay, and submit written findings to the City Planning Commission about its approval, conditional approval, or denial of any certificates of appropriateness. This doesn't say the Historic Conservation Board must provide its advice or provide a recommendation about the COAs. No, the Historic Conservation Board has jurisdiction over the COAs. City Planning Commission has jurisdiction over the final development plan. Look at the next section. It talks about after considering the recommendation of the zoning administrator and the evidence and testimony provided at the hearing, the board makes a decision that the application substantially conforms to the Over the Rhine Historic Guidelines. Therefore, the board approves in bold, all capital, the certificate of appropriateness application. Then there's another clause. So it's done its job. It's approved the certificate of appropriateness. Its decision rendered April 7th. And then it separately recommends approval of PD 76's final development plan based on the drawings. Okay. It's done its job here. It approved the COAs, as the Historic Conservation Board has the authority to do, and only the authority to, or that the board is the only board that has the authority to do. And then it recommended approval of PD 76. That's the recommendation to the City Planning Commission, because the Historic Conservation Board doesn't make final determinations on plan developments, on final development plans, I should say. It makes recommendations on COA. So it's done its job here. Then it talks in A and B on section 5. It says the building permits must be issued before the expiration of the final development plan approval, or the certificates of appropriateness shall expire. Separate things, right? They can expire. There's been a separate decision on it. And then all signs and murals have to go through another separate COA process. It doesn't say, oh, they, come back to us for our advice to the Planning Commission. No, these are independent processes that are part of the larger process, but not so separate that they're not appealable. What's important then to look at next is the City Planning Commission decision. If you look at the notice of final determination signed by Catherine Kjogers, who's the City Planning Commission Secretary, it does not mention the HCB's decision anywhere. If you turn to the first page of the City Planning Commission decision under attachments, it talks about attaching Exhibit E, quote, the official decision of the Historic Conservation Board. And the official decision was nowhere affirmed in this document. It was not ratified. It was not overruled. It was just simply attached as the official decision of the board, and the City Planning Commission then went on to do its job. And I will talk about what its job specifically is and why was not something that we were going to appeal. If you look at number 2, I'm sorry, on the background, paragraph 2, it talks about how there was a prior approval of a certificate of appropriateness. Then if you go to the top of page 2, it says the Historic Conservation Board approved 2 certificates of appropriateness for new buildings and made a final development plan recommendation. The board's job is to approve the COAs and then make a recommendation about the final development plan. And these 2 things are separate and separately appealable. If you go down to the bottom of page 2, this is what the board starts talking about, differences between the concept plan and the final development plan. They do talk about the Historic Conservation Board making written findings, not advice. Findings are decisions, conclusions to the City Planning Commission about its approval, condition approval, or denial. And that's included on Exhibit E. If you go down to the bottom of page 4, again, evidencing that these are separate processes, separately appealable. It says, additionally, all signs will be reviewed through the certificate of appropriateness process. Again, it doesn't say, oh, we'll come back to the City Planning Commission if you have signs, and then they'll send it to the Historic Conservation Board, and the Historic Conservation Board will give its advice, and then it comes back to us to decide if certificates of appropriateness should be issued. That's not the procedure here. If you go to the very end of the document, if you go to page 7 under conclusions. So by the way, the City Planning Commission's made findings and conclusions because appellees focus on the word findings and they claim that findings is just advice. Well, then I guess this is just advice too, if they use the term findings. But they've used the term findings and conclusions. And look at the conclusions here. It says that the final development plan is consistent with the approved concept plan and development program statement. Okay, that's what the City Planning Commission does. They review those 2 things to make sure that they are complementary. Number 2, the proposed mixed-use development will reactivate a currently vacant lot, adjacent empty buildings, increasing housing opportunities and introducing business opportunities in the Over the Rhine neighborhood. Okay, that's a conclusion. Not exactly sure how we would possibly appeal something like that. Number 3, the final development plan is consistent with the goals and plans Cincinnati and the Over the Rhine Comprehensive Plan. Those are the conclusions of the City Planning Commission. That's what the City Planning Commission does. Then in their recommendation, the staff recommends the City Planning Commission approve the final development plan and adopt the city's planning's findings. So if we were to appeal this decision of the Planning Commission, that's what we would be appealing. We would be appealing, is this in accordance with the comp plan? Is in accordance with the concept plan? Those kinds of questions. That's what we would be appealing. That's not what we're interested in appealing. Those are not the issues that we're focused on. We're focused on whether this proposal meets the historic district guidelines in Over the Rhine. And it doesn't. In our opinion, Historic Conservation Board found that it does. They issued a separate written decision using the word approval numerous times. And that is appealable because that is what we are appealing. We're not appealing the question of whether the final development plan is conforming with the concept plan or with a comp plan. That's not what we're appealing. We're appealing the issue of the certificates of appropriateness. So if you look at section 1435.05, and I'll conclude here shortly because I know I'm going on and on. The 1435.05, it says exactly what Mr. Benny alluded to earlier, notwithstanding anything to the contrary contained in this chapter 1435, that includes the section on PDs, or chapter 1449, all appeals of certificates of appropriateness shall be to the Zoning Board of Appeals pursuant to section 1449.01B. All, notwithstanding anything to the contrary, all appeals go to the Zoning Board of Appeals. Now, the Zoning Board of Appeals has jurisdiction. That preserves your jurisdiction over the certificates of appropriateness and the decision that was made. Now, appellees know this. They are aware of 1435.05-5, and they're challenging whether this is a decision. What you've seen from just looking at the face of the document, the contents of the documents, the substance, the title of the documents, you can see that the Historic Conservation Board made a decision. It was issued. It's separately appealable. And let's be absolutely clear here. If we had appealed the City Planning Commission decision, but not the Historic Conservation Board decision, I guarantee you we'd be here today on a motion to dismiss from Appalese that we didn't file an appeal on the Historic Conservation Board decision, because that's a separate and independent decision. So it is an attempt to box us in here. There's an attempt to play gotcha to avoid the merits of the case. Because, in our opinion, the merits are weak. But, we'll get into that. But what we can't do is toss this out simply because, we can't toss this out. There's due process rights. If the code is, doesn't work the way it should, that's up to the City Council to amend the code. But we believe it's crystal clear under 143505 that this board has jurisdiction over the certificates of appropriateness. Again, I don't know why the Historic Conservation Board would have issued a separately appealable decision, and it is within their jurisdiction, absolutely, to issue a decision on those COAs. If the Historic Conservation Board had overruled, if the City Planning Commission had overruled, we would have let me back up. To answer an earlier question, if the Historic Conservation Board decision was overruled by the City Planning Commission, which it wasn't, City Planning Commission just went along with the decision. It didn't overrule it as it could have by a 2/3 majority vote. But if they had, the final development plan would stay in place. It doesn't go anywhere. It's approved, but the COAs are not. So you'd have to go back. The applicant would have to go back to the Historic Conservation Board and show why they meet the district guidelines, amend their application, show why they meet the district guidelines, and then they would be able to come back to the Planning Commission with a approval in their hands. That's the way that would work. And that's how it's intended to work under the code. That's all I have. I don't believe this board can allow the deprivation of my client's due process rights under 143505-5. I believe there's a clear legal right to a hearing, a clear legal duty for the city to hold a hearing on the merits. And we ask you to overrule Appleby's motion. Thank you.
Thank you, Mr. Suter. Board members, do you have questions for Mr. Suter?
Mr. Suter, I have one question. Are you suggesting that by attaching a copy of the Historic Conservation Board's decision as an exhibit to Planning Commission's decision and not exercising Planning Commission's ability to overrule that decision of Historic Conservation, are you suggesting that that was not an approval or of the Historic Conservation Board's decision or an appealable issue at the Planning Commission level?
I believe at the Planning Commission level, if they had done the opposite, and if they had overruled the Historic Conservation Board, they could have done that, but they did not. They could have, but they did not. That is not an appeal of the Historic Conservation Board's decision. That is an ability for the Planning Commission to overrule a lower decision as part of its final development plan approval. They did not do so. So if we were to appeal, what would we appeal? We would appeal that they did not do something. I think the appeal would be to the certificates of appropriateness, which is what we did, and we timely did. Thank you.
So sorry, my question was perhaps inartful. By attaching and not overruling, wasn't that the Planning Commission's approval of the Historic Conservation Board's decision or recommendation or whatever we're going to call it, and therefore making that appealable at the Planning Commission level? You're
You're saying is that decision appealable to the ZBA? It would be if we were going to appeal the final development plan overall, because they've they've approved this as part of the final development plan approval, which we could appeal, yes, but that does not remove the jurisdiction of the Zoning Board of Appeals. Like I said, there's concurrent jurisdiction. It does not remove the jurisdiction of the Zoning Board of Appeals when it comes to the separately issued decision specific to the certificates of appropriateness that was issued on April 9th by the Historic Conservation Board. And if that seems a little messy, and maybe it is, again, that's the way the code is written. That's why we're here. And my client's right to speak on this matter should not be deprived simply because the city's code may be a little messy.
So, Mr. Suter, if let's assume that this motion to dismiss is denied and we proceed to a hearing on the merits of your appeal, and we agree with you, how would that decision impact the Planning Commission's decision in this case?
So if the Historic Conservation Board's decision is overruled by the Zoning Board of Appeals or any other body, the final development plan decision remains, but they would not have the ability to get certificates of appropriateness. So they would have to go back and obtain certificates of appropriateness. It forces the client to actually meet their burden that the project follows the historic conservation guidelines.
So would that then have to go back to if that were the case, would that decision then of the HCB go back to Planning Commission again?
It would be transmitted to the Planning Commission, yes. Okay. Now, the Planning Commission could overrule that by 2/3 majority vote. But that's not where we are. We are at a point where we have a COA application. I'm sorry, a COA decision that's appealable. And we also have a final decision by the City Planning Commission that's appealable. But if we were to appeal that decision, we would not appeal the issues of whether the concept plan is in conformance with the final development plan, or whether the final development plan furthers the intent of the comprehensive plan. Those are not the issues we're talking about. We're talking about specifically about the certificates of appropriateness. And in that case, we have to look to the HCB decision, and the zoning code gives you the jurisdiction to do that.
Are the certificates of appropriateness not part and parcel of the overall final development plan?
They are part of it. They are not, like I said, the fact that they are part of the final development plan process does not exclude the ZBA from reviewing them separately, because they are decisions of the Historic Conservation Board. So there's concurrent jurisdiction here, but you don't appeal to the City Planning Commission to get to overrule the decision of the Historic Conservation Board. They can overrule it, but that is not an appeal. And the fact that we could appeal the City Planning Commission decision and the Historic Conservation Board decision does not, the fact that we can appeal the City Planning Commission decision does not take away our right to appeal the Historic Conservation Board decision. They're separate issues, separately appealable.
Any other board questions for Mr. Suter? If not, we'll turn it back over to Mr. Tepe for any rebuttal.
Thank you very much. I'll defer to Mr. Burke, please.
And I will attempt to be brief. Mr. Suter started and ended his argument based on some deprivation of the due process rights of his clients. Unfortunately, what's not before you today is the transcript of what occurred in front of the Planning Commission. Because if that were there, you would see that virtually all of his clients who are with us today expressed their positions to the Planning Commission, arguing on the issue of the certificates of appropriateness, because they recognized, as Mr. Klingler did when I cross-examined him, that they didn't have an argument of substance on whether or not the final development plan conformed with the preliminary plan, because it did. And Mr. Suter has essentially conceded that today. All of their arguments of any substance in front of the Planning Commission related to the certificates of appropriateness. There is no way that they can legitimately argue that they have been deprived of their due process rights under those circumstances. They've had ample opportunities to make their positions known, and they have taken advantage of that at multiple different public meetings and hearings. Mr. Benny's question about section 1435.05 and the notwithstanding language that Mr. Suter relied on, it's critical to recognize that that refers to notwithstanding anything contrary contained in this chapter 1435. That's the Historic Conservation Board. But here you've got to go back to 1429, the Planned Development District regulations. The way this process was intended to work and worked in this case is that these appellants had the opportunity to be heard on their arguments in front of the Planning Commission. They took full advantage of that in a very long meeting before the Planning Commission. The Planning Commission, having heard their arguments, voted unanimously to approve this project moving forward because it had certificates of appropriateness and it had complied with the final development plan being consistent with the preliminary plan. There's no deprivation of due process. There's no deprivation of First Amendment rights as asserted in Mr. Suter's memorandum. It's just not true. To suggest, as is being suggested by Mr. Suter, that you can appeal what you want to appeal to the Zoning Board of Appeals because we lost in front of the Planning Commission and we know we're not going to be able to appeal that successfully. That's just not the way this was intended to work. I'd be happy to respond to and one other point. The developer has building permits ready to be picked up. The Planning Commission's decision is final. It is non-appealable. What's the impact of this attempt at a second bite at the apple to those building permits that are ready to be picked up? Thank you.
Do any board members have any final questions at this time? If not, I will entertain a motion to adjourn to private deliberation.
So moved.
Second.
Ms. Powell,
Aye.
Mr. Benny,
Yes.
Mr. Moran,
Yes.
and I vote aye as well. We will adjourn into private deliberation and we will be back shortly. Thank you.
Thank you.